This is Justice, History, and the Law. Lectures, discussions, and interviews from the Robert H. Jackson Center in Jamestown, New York. June 6, 2004. Jack Robbins, the chief prosecutor of the 4th Nuremberg Trial, speaks to the Robert H. Jackson Center. Mr. Robbins prosecuted what later became known as the medical case against the SS doctors and the brutal experiments they performed on concentration camp inmates and prisoners of war.
For Hilda and me, it is a great privilege and honor to be here at the Robert H. Jackson Center. We've heard about it for a good many years. Although I understand it's only 3 years old, it has achieved a prominent place in the history of this country. Robert H. Jackson, of course, was a great hero of mine at Nuremberg. He was a hero to every one of the some 100 American lawyers at Nuremberg who were involved in the 12 trials subsequent to the first big trial in which Jackson was the chief prosecutor. We all at Nuremberg remembered these words from Jackson's opening statement. We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice, he said, is to put it to our own lips as well. That is something that we, each one of us, kept constantly before us. As my colleague in Nuremberg, Henry King, who's now a professor of law, said about Jackson, Nuremberg and Jackson's legacy pervades our understanding of the world today. Indeed, the trial at Nuremberg has become more than a mere historical event. It has become an international aspect of our heritage, of our jurisprudence, even of how we perceive society. The trial ignited a revolution in international law, and it dramatically changed the relationship between individuals and national governments. Nuremberg established our contemporary conception of the international community. Jackson prosecuted the most important trial in history. Well, as Greg said, I was recruited for the Nuremberg trials in the spring of 1946. At that time, I was a litigator in a big Wall Street law firm, Cravath, Swaine & Moore. I was 26 years old at the time and out of Columbia Law School all of 3 years. My litigation experience in New York had been in civil, not criminal cases. I was recruited by Howard Peterson, who was Assistant Secretary of War, and I was recruited for the position of legal aid to the Chief of Counsel for War Crimes, Brigadier General Telford Taylor. Taylor, as the setup piece indicated, was Justice Jackson's deputy in the first big trial, and he became Chief of Counsel upon Jackson's departure from Nuremberg. I was given a leave of absence and in 1948 returned to the Cravath office after completion of my 2-year tour of duty in Germany. As Greg said, I only had one precondition for going to Nuremberg, and that was that Hilda could go with me. So it was arranged that Nuremberg would request Hilda's presence as a CAF2, a file clerk. But we hadn't been in Nuremberg very long until General Taylor learned that she had majored in dietetics in college, and he asked her to be in charge of the feeding of people at the courthouse cafeteria at the Palace of Justice, and she agreed to do that. And so my 22-year-old bride was placed in charge of the cafeteria at the Palace of Justice and the feeding at lunch of more than 1,000 people each day. It was a great privilege to work closely with General Telford Taylor. He was truly a great lawyer, and to accompany him, as Hilda and I did, and as his legal aid on trips throughout Europe, preparing for the 12 war crimes trials that were conducted in Nuremberg. As Greg said, these 12 trials were conducted in the American zone in Nuremberg, and the French and the British conducted trials in parallel with the 12 subsequent proceedings in their respective zones of Germany, and the Russians conducted trials in Moscow. In addition to the preparation and trial of the 12 cases, the Chief of Counsel's office had to decide which individuals were to be tried. We selected the defendants to be tried. We gathered the evidence. We prepared the indictments and conducted the prosecution in the courtroom. As General Taylor's legal aid, I was involved to some extent in all of the 12 cases. I helped collect the evidence and draft many of the indictments. As Greg said, I was one of the several prosecutors in the Nazi doctored medical experiment case, and to some extent in the Einsatzgruppen case, which was case number 9, and I was the chief prosecutor in the Oswald Pohl case, case number 4. Today I want to give a brief overview of the 12 cases and talk in more detail about the medical case, the Oswald Pohl case, and briefly about the Einsatzgruppen case. In total, we brought 177 individual defendants to trial in the 12 cases. And incidentally, thousands of other Germans were processed in denazification court cases in Germany. Most of the persons indicted in the subsequent proceedings were already in American custody, but we did have some interchange of defendants with the British and French, and with Holland, Denmark, and Poland. The British and French conducted war crimes trials, as I said, in their respective zones of Germany. Since the end of the war, the Russians had been and continued to be relentless in their pursuit of war crimes suspects. Hilda and I visited in Moscow with the chief Soviet prosecutor, General Roman Rodenko. We had dinner with Rodenko, including vodka and sturgeon caviar, in the restaurant atop the Russia Hotel in Moscow. This was in 1970. General Rodenko had returned from Nuremberg to his post as Attorney General of Russia. And the main conversation at our 2-hour dinner that night was about Rudenko's passionate, zealous pursuit of war crime suspects a quarter of a century after Nuremberg. Well, each of the 12 cases in the subsequent proceedings, following the first big trial that Jackson prosecuted, each of these centered on a particular professional group of defendants. Thus, among the 177 defendants, there were 39 doctors and lawyers, 56 SS men and police, 26 military leaders, 22 government ministers, and 42 industrialists and financiers. Among the industrialists were the directors and officers of the I.G. Farben Chemical Trust, that was case number 6, the Krupp Munitions Trust, case number 10, and the Steel and the Flick Combine, which dominated the coal, iron, and steel industries, case number 5. At one time, there were 6 trials involving more than 100 defendants, all underway at the same time. Almost 100 American lawyers were employed by the Office of Chief of Counsel, of course not all at any one time, and of course the defense bar far outnumbered the prosecution bar, because each one of the 177 German defendants had 1, 2, 3, and sometimes more defense lawyers. And the German defendants had the best legal talent in Germany in defending them. Among the rights which the German defendants had in the 12 subsequent proceedings, these were, and I must emphasize that they were the result of Robert H. Jackson's insistence in the first big trial. 1, the choice of an attorney. 2, the presumption of innocence. 3, the prosecution having the burden of proving personal guilt beyond a shadow of a doubt. 4, the right for their attorney to cross-examine all witnesses. 5, full access to the documentary evidence in the possession of the prosecution. And 6, the full power of the United States Army to help locate defense witnesses. The 12 cases required more than 1,200 days of court proceedings, and the transcript of these proceedings exceeds 330,000 pages, not counting thousands of documents, briefs, and other records. Which reminds me that when we recently moved from our home in Fort Washington, Pennsylvania, which we had occupied for 49 years, to a retirement community in the suburb of Philadelphia, I came across 40 volumes of the transcript, the typed transcript, and briefs in the medical case. And I knew that moving to the retirement community, I would not have room for those 40 volumes anywhere. So I called Ursinus College, and they were glad to add those to their library. In the 12 cases, 32 persons, mostly state court judges, served as judges in the 12 cases. Chief Justice Vinson of the United States Supreme Court ruled that federal judges could not go to Nuremberg to sit on the trials, so that the state court judges were used, and incidentally, they were excellent judges. All of the 177 defendants who stood trial in the 12 cases 35 were acquitted, that's about 20%, and 142 were convicted. Of the 142 defendants who were convicted, 26 were sentenced to death. That was about 18% of the 20%. All 26 persons in the three cases that I am talking about today, 7 in the doctor's case, 4 in the Oswald Pohl case, and 14 in the Einsatzgruppen case. Of the 118 defendants convicted but not condemned to death, 20 were sentenced to imprisonment for life, and 98 defendants received prison terms of up to 25 years. I must say that I never took particular pride in the 26 death sentences. I had a moral dilemma. I was then and still am opposed to capital punishment. So in my closing statement, I left the decision, of course, to the courts. The adjudications and the written opinions in the cases are much more important than the death sentences. The doctor's case that you heard about was the first of the 12 cases to be tried. The indictment was filed on October the 25th, 1946. The trial opened on December the 9th, 1946, and closed 7 months and 10 days later on July 19, 1947. The case was heard by a bench composed of Walter Beals, who was the Chief Judge of the Supreme Court of the state of Washington, presiding, Harold Sebring, Judge of the Supreme Court of Florida, and Johnson Crawford, Judge of the District Court of Oklahoma. The indictment in the medical case named 23 defendants. Carl Brandt, whose picture you saw, the major defendant in the doctor's case, had been one of Hitler's personal physicians. He was a major general in the SS, and he held the highest medical position in the Reich, directly subordinate to Hitler, with supervisory authority over all military and civilian medical services. Other defendants among the 23 defendants included Lieutenant General Hanloser, who was chief of the medical services of the Army, General Schroeder, chief of the medical services of the Air Force, and Karl Gebhardt, chief surgeon of the SS, with the rank of Major General, and he was president of the German Red Cross. These SS doctors and their subordinates performed cruel and barbarous medical experiments on concentration camp inmates and prisoners of war, experiments which included high altitude, freezing, mustard gas, sulfonilamide, seawater, sterilization, and experiments with incendiary bombs. Inmates at Dachau and Buchenwald were deliberately infected by camp doctors with malaria, epidemic jaundice, and typhus. In order to test vaccines, inmates were forced by camp doctors into tanks of ice water or kept naked outdoors at below freezing temperatures for many hours. Indeed, the true object of many of these experiments was not how to rescue or how to cure, but how to destroy and how to kill. The sterilization experiments were purely destructive in purpose, and the inmates at Dachau and Buchenwald, who were shot with poison bullets, were not guinea pigs to test an antidote for the poison. Their murderers, German doctors, wanted to learn how quickly the poison would kill the victim. Among thousands of other atrocities, the evidence established the murder of 112 Jews who had been selected for the purpose of completing the skeleton collection at the Reich University of Strasbourg. Photographs and measurements were taken of the 112 Jews. Then they were killed. Then various pseudo-scientific studies were made on their bodies regarding race, pathological features, form and size of the brain. Then the bodies were sent to Strasbourg. There, the 112 bodies were defleshed for the skeleton collection at the university. The so-called medical experiments carried out by German doctors in the concentration camp resulted in thousands of deaths. Indeed, the Nazi policy of mass extermination could not have been so effectively carried out without the active participation of German doctors. German doctors were essential to the operation of the concentration camps, deciding on the admission ramps who were fit to be permitted to live temporarily to perform forced labor and who should be promptly killed. German doctors selected prisoners for death, supervised the killings in the gas chambers, and decided when the victims were dead. German doctors joined the Nazi Party in large numbers, and German medical organization actively supported Nazi policies. The Nazi principle of killing as a therapeutic imperative is exemplified in the words of SS Dr. Fritz Klein, a doctor at the Auschwitz concentration camp. Dr. Klein was asked how he could reconcile Auschwitz's smoking chimneys with the Hippocratic Oath. Klein's answer was simple and direct. He said, "Of course I am a doctor and I want to preserve life, and out of respect for human life, I would remove a gangrenous appendix from a diseased body. The Jew is the gangrenous appendix in the body of mankind." The Germans justified medical killings on the basis of life unworthy of life. In accordance with German virulent anti-Semitism, an anti-Semitism that was violent, genocidal, eliminationist, and exterminationist, Jews were considered unworthy of life and had to be annihilated. For the Nazis, the slaughter of Jews was simply a matter of racial cleansing, equivalent to exterminating parasites and vermin. In its judgment, the tribunal said, after finding certain of the defendants guilty, and incidentally, 32 prosecution witnesses were presented and 53 defense witnesses testified, and 570 prosecution documents were introduced, and 900 defense documents were introduced. The court said in its opinion, "Judged by any standard of proof, the record clearly shows the commission of war crimes and crimes against humanity, substantially as alleged in counts 2 and 3 of the indictment. Beginning with the outbreak of World War II, criminal medical experiments on non-German nationals, both prisoners of war and civilians, including Jews and, quote, asocial persons, were carried out on a large scale in Germany and the occupied countries. 16 of the 23 doctors were found guilty. 7 defendants were sentenced to death by hanging. 9 defendants received prison terms ranging from 10 years to life, and 7 of the 23 defendants were acquitted. The sentences imposed by the tribunal were confirmed by the military government, and after the United States Supreme Court, by a 5-3 vote, Justice Jackson not participating, they declined to review the case. The executions were carried out at the Landsberg prison. Greg has referred to the Nuremberg Code, and I won't go into detail on that. It is the basis, as the video said, of the requirement that voluntary consent of the human subject is absolutely essential to human experimentation. That was not established beforehand. It has been established by that court decision and is more or less followed throughout the world today. Another example of the findings of the court that have withstood the test of time is the so-called Nuremberg Defense. It was established by the courts in Nuremberg, and first of all by Justice Jackson, and in the first big case, that superior orders by a commander is not a defense to criminal action. It may be used as mitigation of the offense, but it is not a defense. The Pohl case, which has been referred to, is the United States against Oswald Pohl, case number 4. The defendants were Lieutenant General Oswald Pohl and 17 other officials of the Economic and Administrative Office of the SS. This department of the SS was in charge of administering the thousands of concentration camps, and there literally were thousands of concentration camps in Germany and in the enslaved countries. This department of the SS also managed the economic enterprises which were owned and operated by the SS, such as mines, quarries, and brick factories located near the concentration camps. The 18 defendants in the Pohl case were charged with war crimes in the operation of the camps, in which millions of Jews, Poles, Russians, and Gypsies were systematically worked to death. Through the infamous Action Reinhardt, which I'm sure you've heard of, these defendants systematically looted the personal property of Jews, including feather beds, baby carriages, blankets, table silver, eyeglasses, furs, jewelry, and all other articles of personal property having any value. When the Jews were killed in the concentration camps, additional loot became available, including clothing and hair and gold from the teeth which were removed from the corpses. The Nazi state acquired 100 million Reichsmarks of loot through this program. As chief prosecutor in the Oswald Pohl case and preparing the case for trial, I took the deposition of Hermann Goering, Field Marshal, Commander-in-Chief of the German Air Force, successor to Hitler after Hess. I interrogated Goering just a few days before he was sentenced to death by hanging. I recall that Goering had lost a great deal of weight. He had weighed about 300 pounds when he was captured, and he was down to 186 pounds, and his military uniform, stripped of insignia, was hung on him like a sack. He saluted and clicked his heels, and when he entered the room, and he assumed that he was in complete charge of the interrogation chamber. Although Goering admitted his complicity in the use of slave labor in the concentration camps, he denied any knowledge of the horrible conditions in the camps. As you remember, Goering committed suicide on the eve of his scheduled execution on October the 15th, 1946. Pohl and 3 other defendants were sentenced to death by hanging, 4 of the 18. 11 defendants received prison terms ranging from 10 years to life. 3 defendants in that case were acquitted. Judge Masmano, in his concurring opinion, Masmano incidentally was a Supreme Court justice from the Supreme Court in Pennsylvania. In his concurring opinion in the Oswald Pohl case, he described medical experiments in detail. He said this mania for experimentation was carried to the point where legs at the hip joint were removed from psychopathic patients to determine if the amputation of legs might affect the mental condition of the patient. He also said, in his opinion, one searches in vain for a document which proclaims that as a result of all this experimentation there came to light not a startling scientific discovery, but even a simple improvement in any normally prescribed treatment for a peacetime ailment or a wartime injury. In its unqualified condemnation of forced labor, the tribunal in the Pole case said this: under the spell of National Socialism, these defendants today are only mildly conscious of any guilt in the kidnapping and enslavement of millions of civilians. The concept that slavery is criminal per se does not enter into their thinking. The court said further, the electrically charged wire, the armed guards, the vicious dogs, the sentinel towers, all these things are blandly explained by saying, why, of course, otherwise the inmates would have run away. They simply cannot realize that the most precious word in any language is liberty. There is no such thing as benevolent slavery. Involuntary servitude, even if tempered by humane treatment, is still slavery. Well, the most gruesome of the three cases that I've mentioned was the United States against Otto Olendorf, case number 9, commonly known as the Einsatzgruppen case. The Einsatzgruppen were special units of the SS that followed the German army during the invasion of Russia. Their mission was the immediate slaughter of all Jews, Gypsies, and Communist Party members in the occupied areas. It was established that 1 million Jews and others were liquidated in Russia by the Einsatzgruppen. The 24 defendants in the Einsatzgruppen case were commanders and other officers of these units of Einsatzgruppen, and the trial was widely described as the biggest murder trial in history. The direct case in the Einsatzgruppen case, the case for the prosecution, based entirely on captured documents, and most of the cases of the prosecution in the 12 cases were based on captured documents. In the Einsatzgruppen case, the prosecution took only 2 days to present its case, and the defense took 136 trial days, or 5 months. The tribunal in the Einsatzgruppen case declared that the facts, quote, are so beyond the experience of normal man and the range of man-made phenomena that only the most complete judicial inquiry and the most exhaustive trial could verify and confirm them. The charge of purposeful homicide in this case reaches such fantastic proportions and surpasses such credible limits that believability must be bolstered with assurance 100 times repeated. Each man at the bar has had the benefits of considerable schooling. 8 defendants are lawyers, 1 a university professor, another a dental physician, still another an expert on art, 1 is an opera singer, gave concerts throughout Germany before he began his tour of Russia with the Einsatz Commandos. All Jews were to be eliminated, this is continuing from the court's opinion, but no precise definition of Jews was furnished. Thus, when one of the Einsatzgruppen reached the Crimea, its leaders did not know what standards to apply in determining whether the Krimtashafts they found there should be killed or not. It was rumored that somewhere along the arterial line which ran back into the Dem Pass, some Jewish blood had entered into the strain of these strange Krimtashafts. If this were so, should they be regarded as Jews and should they be shot? An inquiry went off to Berlin, In due time, the reply came back that the Krimtashaks were Jews and should be shot. They were shot. The captured documents left no doubt that the incredible massacres charged in the indictment had in fact occurred. The following is a typical passage from an Einsatzgruppen report, which was captured and introduced into evidence. Quote, "A large-scale anti-Jewish action was carried out in the village of La Casa. In the course of this action, 920 Jews were executed with the support of an Einsatzgruppen. The village may now be described as free of Jews." Otto Olendorf, the principal defendant, was the commander of Einsatzgruppen D and a major general in the SS. Olendorf admitted that his Einsatzgruppe D had killed 90,000 Jews in the Ukraine and the Crimea, but he defended the slaughter on the ground of military necessity, even to the killing of Jewish children. This is from Olendorf's testimony. Children were people who would grow up, and surely, being the children of parents who had been killed, they would constitute a danger no smaller than that of their parents. Upon judgment, the tribunal sentenced Olendorf and 13 other defendants to death by hanging. 2 more received life sentences and 5 prison terms of 10 to 20 years. None of the 24 defendants in the Einsatzgruppen case were acquitted. Well, it ought to be remembered that the fundamental reason for the Nuremberg trials was that there was no preferable or even acceptable alternative for handling the practical and pressing problems of what to do with the surviving Nazis. Nuremberg was based on the view that, as Robert H. Jackson said, we cannot await a perfect international tribunal or legislature. Nuremberg was also based on the view, as Jackson said, that international law must develop as the common law has developed through custom, agreement, and judicial precedent, such as the Nuremberg trials themselves were intended to provide. The great goal of Nuremberg was the amplification and clarification of international criminal law to strengthen the foundations for world peace and order for the future. I believe the major legal significance of the Nuremberg trials lies in those portions of the opinions which deal with the area of personal responsibility for international law crimes. The Nuremberg tribunals themselves, international, applied international penal law to international crimes. I will close with the words of Telford Taylor, which he wrote in 1949 in his final report to the Secretary of the Army. He said, "Nuremberg cannot be forgotten by those who created it. The criminals and their wretched deeds may pass from memory, but the trials we have no right to forget. He who undertakes to render judgment under law assumes a responsibility which he may not thereafter shed. 4 nations signed the London Charter and Control Council Law No. 10, the 2 jurisdictional cornerstones of the Nuremberg trials, and 19 other nations have formally proclaimed their adherence to the principles embodied therein. Representatives of the United States took the lead in formulating those principles and in establishing the Nuremberg tribunals for their enforcement. Thousands of Germans and Japanese have been tried under those principles. Those found guilty have been punished. We may not, in justice, apply to these defendants, because they are German, standards of duty and responsibility which are not equally applicable to the officials of the Allied powers and to those of all nations. The great question today is not whether the Nuremberg principles are valid, but whether mankind can live up to them and whether it can live at all if it fails. Thank you.
Maybe we have time for one or two questions. Anybody have a question for Mr. Robbins? Yes. Go ahead, Phil.
Bill?
Was there a model for the separate prosecutions conducted by the Allies, or did they each formulate their own procedural rules, etc.?
I really cannot speak for the French or the English or the Germans or the Russians, but the framework for the 12 subsequent cases in Nuremberg in the American zone were modeled entirely on Justice Jackson's formulation in the first big trial. That was the International Military Tribunal at which judges from the United States, England, France, and Russia were judging, and the prosecution also represented those 4 countries.
One more question? Yes, sir.
Yes, in terms of the medical side of things, it's come to our attention that
A little louder, sir.
it's come to our attention that kind of pilot project for extermination developed in mental institutions. They phrased it as life undeserving of life. And they scrupulously, through their methodology of keeping records, went through the records showing how if they were criminalized, that was cheaper than treatment. And then in the final analysis, they had execution chambers in the cellars or basement of these institutions, such as Panama.
Yes,
Can you comment on it?
that's exactly right. The euthanasia program did start in the mental institutions, and it soon spread, though, to others who were considered unworthy of life, including Jews and gypsies and communists. But you're exactly right. The start of it all occurred before the war in the institutions for the mentally defective and that sort of thing.
On behalf of the Robert Jackson Center, I want to thank, just 1,000 thanks, Jack, for everything you've provided to us today. Also like to thank the folks from Rotary, Doreen Sixby, MNT, and your principal Rotarian, Stan Weeks, who at 91 made a special effort here just to come to hear you, Jack. And Sarita, welcome. Welcome and for joining us today. Thanks, everybody. Appreciate it.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as Chief Prosecutor at the Nuremberg trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716-483-6646.